Now we turn to the issue of causation. This is perhaps the most complicated set of issues within negligence, and it's possible to make it fairly complicated on the multi-state. On the essays, probably the most common mistake is a lot more basic than figuring out the nuances of proximate cause. The most common mistake people make on the essays in negligence is to fail to discuss each element with a reasonable amount of detail. And so when we get to causation, the sharper answers typically will have separate sections on actual cause and proximate cause. Actual cause can also be considered just the plain but-for cause. And here, all we're trying to figure out is whether or not the plaintiff would have been injured had the defendant not done the act that the plaintiff is claiming was negligent. So the but-for causation. This can be complicated by a number of fairly standard issues. The first of these is where there are possibly multiple causes of the plaintiff's injuries. The most typical of these being where several defendants are acting at the same time. Where we have multiple causes, and we acknowledge that more than one of these causes did in fact contribute to the injuries, we will look at each defendant and ask ourselves whether or not that defendant was a substantial factor in the plaintiff's injuries. If the answer is yes, we're going to find liability. If the answer is no, we aren't. It's really quite simple and straightforward. Where we have got alternative causes, and we're not entirely sure whether or not each defendant caused the harm, the burden of proof shifts to the defendant, and the defendant has to establish that he or she in fact did not cause the injury suffered by the plaintiff. Where we've got multiple defendants, we consider often joint and several liability. Here, if there are multiple defendants, all of them contributing to the plaintiff's harm, we will find them each liable for the full extent of the plaintiff's injuries, and then we'll let them apportion fault amongst themselves. Obviously, the plaintiff is only going to be allowed one recovery, but each of the defendants will be fully liable to the extent that it can't be proven which defendant really is responsible for a specific percentage of the plaintiff's injuries. Also, from state to state, the rules vary somewhat about the effects of a satisfaction and release. The majority rule is a defendant can be released by a plaintiff without that release affecting the rights of other potential defendants. But again, local law varies, and this is a point that you may well want to check on locally. Make sure that you have the details straight about what law actually governs a dispute in your state. Where we've got issues of multiple defendants, often we will have issues of contribution and issues of indemnity. A contribution issue is one in which multiple defendants each pay a proportion of the plaintiff's injuries, either based on a jury's findings or based on their own negotiations. Also, with regard to indemnity, this is a situation in which the liability is shifted from one defendant to another. So an indemnification is where the more culpable defendant makes full compensation and indemnifies other defendants. All right, basic but-for causation actually is the more straightforward of the two issues. Establishing whether or not a defendant is a but-for cause of the plaintiff's injuries usually isn't that difficult. But once that's done, the plaintiff has to go a step further. The plaintiff has to show that the defendant is not merely a but-for cause, but also a proximate cause. And here's where the difference between the Andrews and Cardozo views comes into play. The Andrews view basically would say anybody who is a but-for victim of the defendant's conduct ought to be able to recover. But the Cardozo view narrows it only to foreseeable plaintiffs being able to recover, and this is where there is a reasonable amount of room for factual analysis on an essay, and again, you can be questioned on this point quite closely by the multi-state. Finally, we see that a plaintiff is entitled to seek full recovery from each of multiple defendants, but in the end of the day, the plaintiff is only entitled to one complete recovery. A couple of other issues come up related to causation, but to my way of thinking, somewhat subsidiary to them. The first of these is one of the areas where the law of torts directly touches the law of real property, and that's with regard to injuries that are sustained by a plaintiff on the defendant's property. So owners and occupiers of land are a class of defendants which are commonly discussed on bar exams and law school final exams all over the country. And your job is to understand what duty is owed to the various types of people that can come onto real property. And we also realize up front that, by and large, the only liability that a defendant can face is for so-called artificial conditions on the property, things that were done to the land by people. Land in its natural condition is pretty much safe as far as a defendant is concerned. Obviously, on a bar exam, the land is dangerous to all plaintiffs, and most of the people that enter land on bar exams figure out some way to sustain an injury. So the first thing that we consider is the duty that is owed by owners or occupiers of land to people outside the land. And typically, there is no duty except to the extent that artificial conditions on the land can cross the property boundaries. And so to the extent that we've got a defendant who is doing something dangerous, a crossover to strict liability, the topic that we will touch on right after we're finished with negligence. There, where something that's happening on the land hurts somebody off the land, well, at that point, the owner and occupier will be found responsible, typically in negligence, although depending on the activity, strict liability may be incurred as well. With regard to the duties owed to people that are on the premises, we focus on three different categories: trespassers, licensees, and invitees. And you will see plenty of practice MBE questions on this point, and a fair number of practice essay questions as well. There are a fair amount of very fine details relating to this law, and obviously the purpose of this presentation is not to recite all of them for you, but just to identify that they are out there. Remember, there are a fair number of multi-state questions on negligence, and they find a way to test many of these little details. So, remember that there is basically no duty owed by an owner or occupier of land to an undiscovered trespasser. However, there are duties that are owed to anticipated trespassers, both grown-ups and kids who may show up as a result of an attractive nuisance. And under these circumstances, there is a duty owed by the owner and occupier of land. With regard to a licensee, the owner and occupier of land has to warn of dangerous conditions and make safe. And with regard to an invitee, there is all of the duties that are owed to a licensee, but the owner and occupier must also make reasonable inspections and take some personal responsibility for making sure that the property is safe. Now, there are a couple of other issues that relate to causation that we may think of on different parts of the torts outline. First, there is the idea of pure economic loss. And when we say pure economic loss, we mean economic loss in the absence of a physical injury to the person or property damage. And the basic rule is pure economic harm cannot be recovered in negligence. Let me give you one quick example of pure economic harm. Suppose we've got a case where the defendant negligently drives his motor vehicle right through the front door of a restaurant and damages the building badly enough that the restaurant has to close for a month. Well, nobody would argue the fact that the driver is going to be liable to the restaurant for property damage, for lost profits to the extent that they can be proven, etc. But suppose there is a waitress who works at this restaurant who isn't even on duty the night of the accident. She is not personally injured, none of her property is damaged. But as a result of this incident, she loses her job. She would argue, I've been hurt as a result of the negligence of the plaintiff. I'm going to sue that plaintiff for my losses. And the defendant would argue, you weren't even in the building, you weren't hurt, your property wasn't damaged, your losses are purely economic. and therefore you should be denied a recovery, and that defense would win. That defense prevails in America because pure economic harm sustained without personal injury or property damage can't be recovered in negligence. An interesting minor point, but one that is almost certainly worth a couple of points on the next administration of the bar exam. Now, suppose we've got claims for intangible injuries like mental distress that don't arise out of physical harm. That's a more complicated issue as well. I encourage you to go forth and do many practice questions. You'll see that this is not very commonly a correct answer, but the law is in play and it is a sort of a subtle area. Let's next consider the liability of a defendant for the negligent acts of others. And the classic situation, and by far the most commonly tested situation, is the employer-employee relationship. An employer is going to be vicariously liable for torts, particularly negligence of employees, so long as that employee was engaged in the course and scope of activities relating to employment. So, where we have a situation where the defendant company, the employer, is a pizza restaurant, and the victim was injured by a car crash caused by a delivery of a pizza. Someone crashes a car while he or she is in a hurry to deliver pizza quickly. Well, that's a classic situation where the employer is vicariously liable because the defendant's conduct was done directly as part of the employee's job duties. Now, a somewhat more subtle question would be, is the employer liable for a traffic accident caused by a driver of a company car after work on the way home? And the straight answer that I will offer in this presentation is probably not, but we'll see practice questions where it's a somewhat more complicated issue than a plain statement of the black letter law might imply. With regard to independent contractors, their liability cuts off. So if we've got, for example, a contractor who has an independent contractor do some technical work, it is possible that the general contractor will not be liable for the conduct of the subcontractor to the extent that there really is a clear distinction and the general contractor is not supervising the subcontractor. Finally, with regard to the parent-child relationship, typically parents are not liable for the intentional torts of their children or for their negligence, except to the extent that the parent is aware of a dangerous proclivity of the child and at that point may well have a duty owed to the general public to protect the public from, say, a mentally disturbed child. Finally, the last big issue in negligence is damages. And the most important idea to remember about damages in negligence is punitive damages are not available. Where a defendant has been merely careless, punitive damages cannot be recovered. So, what a plaintiff will do is argue the same facts that add up to negligence and claim that they are reckless. Wanton and willful misconduct, something that falls short of specifically desiring to hurt somebody, certainly can justify an award of punitive damages. Let me give you a quick example. Suppose we've got a defendant at a party on a rooftop lounge, and as a result of carelessness, the defendant knocks a drink off of the railing, it falls several floors, and it hurts somebody on the street. That's negligent, and the defendant's going to be liable for compensatory damages, but not for punitive damages, because the act was not reckless. Now, compare that to a situation where a bunch of rock and roll guitar players are on the roof, and one of them throws a television off the roof deliberately. Well, that person may not have aimed the TV at the victim, but that conduct is wanton and willful. It's reckless, and punitive damages are available where the plaintiff shows recklessness, but no punies where the defendant is merely negligent. So, we are focused in negligence on compensatory damages, and once again, the issue of foreseeability can come to the fore. With regard to personal injuries, a plaintiff is going to be allowed to recover for all of the costs of the medical treatment and also for pain and suffering that came with the injury. The plaintiff is entitled to be paid for that. With regard to property damage, we will calculate the damages in the same way we would for conversion purposes. What is the replacement value on the date of the injury? So fluctuations in price are not going to be relevant. We'll focus on when the property was damaged. We'll assess damages at the replacement value on that date. Remember that a plaintiff has got a duty to mitigate his or her damages. Just because a defendant has caused harm doesn't give the plaintiff a license to run up additional damages. So a plaintiff has a duty to seek reasonable medical treatment, a duty to effect repairs to property where it's likely that the failure to repair will lead to substantially greater harm, etc. The plaintiff has a duty to mitigate. So always look for what happens in between the act of carelessness and the final claim for recovery. There's one final issue of proximate cause that is relevant here, and this is the idea of intervening causes, where we've got a negligent defendant followed by an act by a subsequent negligent or willfully wrongful defendant. The issue is whether or not the chain of causation is broken. Where the chain of causation is broken, defendant number one is off the hook, defendant number two is on the hook for all of it. And this issue comes up again in damages because we have to allocate blame according to causation. So where there are multiple defendants and we have decided that one defendant is truly liable, the other defendants are absolved completely, and that one defendant will have to pay all of the compensatory damages. Also remember a tiny little detail, the collateral source rule. The collateral source rule. Here, if the plaintiff receives some payment, typically from insurance, that's not going to reduce the liability of the defendant. We're not too worried about the plaintiff getting a double recovery because typically a plaintiff will have a contractual obligation to reimburse an insurance company for any damages that are paid by a culpable defendant. But in the event that there is to be a double recovery, it's better for the plaintiff to get paid twice, once by insurance and once by a defendant, than for a plaintiff to be denied a recovery altogether. Well, that leads us to defenses. With regard to the intentional torts, we covered the defenses as we considered the theories of liability. With regard to negligence, the biggest defenses are contributory or comparative fault. We know that contributory negligence is the harsher way of looking at it. That's the philosophy that says even a plaintiff that has been a tiny bit careless himself or herself is denied a recovery. In a comparative fault jurisdiction, which is today the majority, we will allocate or reduce the recovery based on the comparative fault of the plaintiff. Also, the last clear chance doctrine and assumption of risk doctrines afford potential defenses to an otherwise culpable, negligent defendant. And that wraps up a consideration of the most important issue on the bar exam, negligence.